Sidang. Hello, I am Shaquan Gill with the Department of Public Information. Today, Justice Sandil Kisoon made a very important ruling. The ruling happening at the High Court here in Guyana saw Justice Kisoon rule on very important matters referring to the teacher strike. There were two important declarations that were made. Justice Sandil Kisoon handed down the ruling, rather, on whether teachers should be paid while they were engaged in strike action, as well as if the government of Guyana was within its remit to discontinue the collection and disbursement of dues. But before we get into today's ruling, here is what led us to this point. GTU said that the government refused to meet and discuss pressing issues affecting teachers. The Ministry of Education, however, said that the allegation is patently false, insisting that the government has had ongoing discussions with the union since the PBPC assumed office in 2020. As a result, on February 5, some teachers walked off the job. This led the government to announce that it will not pay those teachers for the time they engaged in strike action. Also, the government revealed that it will no longer remit dues to the GTU on behalf of teachers. And that's how the case ended up before Justice Sandil Kisoon at the High Court. Today, the High Court ruled the following. 1. That the teachers who participated in the strike action be paid in full. And 2. That the government continue its remittance of dues to the Guyana Teachers Union. To continue this discussion, DPI's Nazim Baksh is in studio with Attorney General and Minister of Legal Affairs, Senior Counsel Anil Nandlall.
Thank you, Shaquan, for that update, and thank you, Mr. Attorney General Anil Nandlall, for joining us this Friday afternoon. I know you made some comments outside of the court, but for our audience that are joining us now for the first time, what's your reaction to the High Court ruling?
Thank you, Nazim, for having me. The decision of the Honorable Justice Kisoon is one that I'll describe as shocking, unprecedented. It constitutes judicial overreach. It impacts negatively upon the separation of powers. It has encroached on the lawmaking functions of Parliament. It has the effect of turning the law in relation to industrial relations upside down. And for all those issues to which I have alluded, the case has far wider implications for the legal system of Guyana, for the industrial environment of the country, and for social order. And in the course of my discussions with you, I will attempt to dilate and elaborate on the various repercussions that the decision will have, and the various errors, I believe, which have plagued the judge's reasoning from top to bottom. But I want to also, from the inception, Nazim, restate our government's commitment to workers' rights, respecting trade unionism and trade unions, respecting collective bargaining, respecting all the industrial practices and principles to which we consider ourselves married, and whatever actions the government takes here must not in any form or fashion be interpreted as adverse to our unwavering commitment to the working people of this country. As I go into my presentation, I hope that I will be able to establish beyond doubt the dangers that this ruling will present going forward, not only for the government, but for the private sector and for employers and employees everywhere.
Right. So there's a lot to unpack.
And one last point that I want to make. Where this judge has taken us and taken the law, no other country in the Western Hemisphere has gone. No other judiciary has made the type of pronouncements that this judge has made in this ruling. And that is why it is of monumental importance that this matter be reviewed by our highest court, if possible, and that there be a stay of execution against the ruling in its entirety. And that's what the government plans to do.
There's a lot there, and I want to unpack as much as we can this afternoon. But let's start with overreach. How did Justice Sandal Kisoon overreach? It seems I was in court for the beginning of this trial, of this hearing, and I didn't see the case. I had a hard time seeing where the case was. But now we get to the end of the case, and there seems to be a case that he somehow resurrected out of nothing, may I say. But basically, I'm asking you, how did the case come about here, and what was the overreach of this judge?
So let's deal with what case was presented.
Right.
The judge from the bench, in his ruling today, a marathon one, lasting several hours, in the course of that ruling, expressly acknowledged that the pleadings through which the case was presented was inadequate and wholly deficient. In his own words, he said, in referring to my objections, agreed that the case could not have withstood judicial scrutiny. And I'm borrowing his language. The case as pleaded could not have withstood judicial scrutiny. Now, having formed that view, that should have been the end of the case. The case should have been dismissed, and the applicant perhaps could have been given another opportunity or take another opportunity to construct a proper case and present it to the court. Now, civil cases, and this is a civil case, are presented by way of pleadings. And we have rules of court which stipulate how pleadings are constructed and how reliefs that the case seeks are expressed, and that each relief that you claim must be related to a right, and you must cite the law that confers that right and show how that right has been violated. So if it is a section of the Constitution that you are relying on, that you want to enforce, if it is, let us say, freedom of assembly, then you have to say which section of the Constitution, and then you have to put out in your pleading how this freedom of assembly of yours was infracted, and give the evidence now to support that alleged infraction. So when the case is before the judge, there is a connection. There is the law first that you are seeking to invoke. There is the allegation of a breach of the law. Then you particularize what that breach is, and then this is the supporting evidence that ought to yield the grant of the remedies. If you go through this case and you look at the pleadings presented by the lawyer who presented the case, you will see, I think he claimed 18 reliefs. 18 reliefs. None of them related to no work, no pay. None of them related to whether the strike is illegal or unlawful. And many of the issues that the court decided are crucial for determination were not raised on the pleadings. And these technical objections were made by me and supported by authorities, including judicial pronouncements from the Caribbean Court of Justice and from the Guyana Court of Appeal, the Privy Council, and several courts around the Caribbean and the Commonwealth. This is a High Court judge. There is something called the doctrine of stare decisis, which means, in essence, that an inferior court is bound by the ruling of a superior court. So if I cite a Court of Appeal decision to a High Court judge on a particular issue, the High Court judge is bound by that Court of Appeal ruling. Worse yet, if I cite a Caribbean Court of Justice decision on the point, which is our highest court, these principles were ignored by the judge.
Right.
As I said, he expressly recognized the inadequacy of the pleadings, but yet decided to proceed to continue to hear the case.
There was 22 items listed for relief.
18, I think.
18. And not one of them was strike and pay.
None was strike and pay. And 80% or more of his judgment, of the judgment of the court, 80 to 85%
Was on that.
related to strike and pay. And that was not pleaded before the court.
That's amazing. So
That was not pleaded.
Yeah, I mean, the judge also said that a common law principle cannot override a constitutional principle. But our experience, as you rightfully said a moment ago, that nowhere in the world a person on strike, an employee on strike, can demand wages and salaries for work not done.
So, look, the Commonwealth of Nations, all inherited a legal system from Great Britain through our colonial experience. So when we speak about the common law, we are speaking about the English common law. And that English common law was supplanted with the tentacles of colonialism in every part of the British Empire,
Including Canada.
including Canada
India,
and so on.
yeah.
So you have the common law of England in all these countries. Strike was once illegal in England. Strike was a criminal act. You could have been charged with a criminal offense for striking. You could have been charged with loitering. You could have been charged with a conspiracy to commit a whole series of offenses if you decided to strike. Union workers who used to go on the premises of employers to encourage people to strike, they used to be charged with trespass. If you struck during working hours, you could have been charged with trespass and public nuisances and a whole set of criminal offenses. That was the state of the law a few hundred years ago. The law evolved to recognize strike as a legitimate legal expression in the armory of the worker. That is how industrial relations developed. So from a criminal act, it became a legal act. It didn't crystallize yet into a right, a legal act. And that is where it is in Guyana. When we got independence, that was the state of the law. In Trinidad, now let's examine industrial relations. The labor movement was birthed first in the Caribbean. And out of the labor movement came political parties.
Yes.
When the political parties began to agitate for independence, you had an amalgam of politicians and labor leaders. Labor sentiments were high. Labor enthusiasm was high in the region during the 60s and even in the 70s. When the independence constitution was handed down throughout the Commonwealth, including the Caribbean. They used a Westminster model, a model crafted at Westminster and handed it down. It was common in almost all the countries. So they list the Bill of Rights, which they took from the United Nations Charter of 1948. And that was the mainstay of the fundamental rights and freedoms that they crafted and put into the Westminster Constitution, and they give everyone. Included in those rights was the freedom to associate, which included the freedom to form unions.
Right.
Very early in the 60s, a case went to the Privy Council from Trinidad by the name of Collymore and the Attorney General. It is regarded as a watershed case for industrial relations. And in that case, they were arguing a whole set of things. The right to form a union, the right to associate includes the right to form a union, which nobody disagreed with. Subsequently, constitutions added that. The court subsequently ruled that right to associate include a right not to associate, so that was an implicit right. And then a strike came, and the matter fell for determination in Collymore. The issue of collective bargaining, etc. A whole host of issues were put before the court. And prominent among them was whether a right to strike exists at common law, and whether a right to collective bargaining exists in the then formulation of the Constitution. Trinidad and Guyana had almost the identical
And in law,
one.
were these two things linked as one right, or were
No,
they
separate, but part and parcel of trade unionism, which the Constitution recognized, right? In a very detailed judgment, Sir Hugh Wooding, after whom they named the Hugh Wooding Law School, delivered a judgment, which was upheld unanimously by the Privy Council. It was a judgment that was hugely criticized by politicians and the labor movement and workers across the region. But Hugh Wooding had to settle the law based upon the Constitution that was there at the time. He had to temper expectations, and he did that. In essence, he ruled, you have a right to form a trade union, but that right did not extend to the objectives of the union. Right?
Interesting, yeah.
Not the objectives, but the right to form the union.
To form the union, right.
And that's where it ended. But you have a common law right to strike. You have a common law freedom to strike. Not right, freedom to strike.
Right.
Because it was once illegal and criminal, it was made legal now. So you have a freedom to strike. However, that freedom was always subject to conditionalities. One of those conditionalities were you are going to suffer no pay if you strike. You are also liable to be dismissed if you strike.
Right.
You are also liable to be disciplined if you strike. But you have a freedom to strike. Now there is a juridical and jurisprudential difference between what is a right and what is a freedom. A right is an entitlement. It's something that you can exercise with, I would say, impunity. A freedom, however, is a facility that contains options and choices for you.
Right.
You are at liberty to choose any of the options. But you must exercise that choice and that option knowing that you are going to be bound by the consequences of the options that you chose.
Right.
And that is how the principle of no work, no pay was examined.
But this judge.
So let me get to where the judge is.
Yeah, right.
That was the position in Guyana, that is the position in Guyana pronounced upon by our courts up to 1977 in a case called Muhammad Ali that the court quoted.
Quoted, yes.
Right? What has changed since? Now let me explain to you what happened. In 2001, we had some constitutional changes through a constitutional reform process.
Right.
It was articulated before that commission that we must constitutionalize strike actions. And the record is there. Now, and a recommendation was made to that effect. The judge quoted from the Hansard, and you're quoting the Hansard of politicians speaking. And when politicians speak in that parliament, they speak loosely. A politician who is not a lawyer would not appreciate the difference between a freedom and a right.
Yeah, they can conflate
So
it.
what change was made to the Constitution that impacts this case that the judge is holding on to? Now, that very provision, Article 147, the whole provision was repealed and a new one replaced.
Right.
Now, they added to that provision, which was originally there, the right to assemble, the right to protest, the right to march, the right to do a whole set of things. And then below that, they included you have a freedom to strike.
Wow. Okay.
So it's not that the draftsman was not alive to the distinction. What the draftsman in the new 147 of the Constitution wanted to make a right, the draftsman made it a right. And I put the two constitutions before the judge.
Right.
I said, this was the before, and this is the after. I even made the point, jocularly, that at the time when they were conducting that exercise, there was no shortage of paper or ink in the country. So if the draftsman wanted to put a right to strike, it's only S-T-R-I-K-E.
Yeah.
He would have included it where he put right to protest, right to assemble, right to demonstrate.
Right.
He didn't do it. He come down to another section and he says freedom to strike. What he did there was simply to codify the common law. What you had before, we are putting it in the Constitution now because the recommendation was to constitutionalize it.
But this judge flipped the narrative.
The judge says once it is there, he refuses to see a distinction between right and freedom. Though I drew it to his attention. Now there is a marked distinction between the two as I've articulated before. And there is a reason why. When you go back to the recommendations of the Constitutional Reform Commission, you know what the recommendation says? That the strike action must be constitutionalized with due limitations. You know what a limitation is? To preserve the right to no work, no pay principle. And here why. And that's the problem that the judge has put the law in. By reading into the freedom to strike a right to strike, and now ruling that if you exercise this right, you're entitled to be paid, what he has done, and what I caution him against doing, is to trample now upon another person's right.
Yes.
The worker, the employer, has to now pay for work not done. The money that the employer has to pay is recognized by law and the Constitution as his property.
The property of the people of Guyana.
Property, no, let's deal with a private sector situation.
Okay.
That's why I don't necessarily want to involve the state.
Okay.
I want so that the people out there can understand how the law now has changed.
Yeah.
So the employer now, the Constitution protects his private property. And he can't lose it unless by due process of law.
Right.
Right? And without receiving valuable compensation. He can only lose it by getting valuable compensation. Now, when a worker strikes, that worker has to be paid.
Right.
That employer is not getting no reward. He's not getting any compensation, but he's losing his property.
So, in other words, you're saying that this judge has enacted law
So,
in this
so,
ruling.
so that is the state of disarray and the inequitable nature now that the law is placed by virtue of this ruling. Now, you're asking me, what has he done here? What has the judge done here?
Right, because the role of the courts is to interpret law,
That's correct.
not to enact law.
So that is why I said...
That's the job of the government.
That
to
is
enact
why
law.
I said that there is judicial overreach and there is, in my respectful view, infringement of the doctrine of separation of powers. Now, if, as a matter of policy, the country believes that we should change our law to bring it to where the judge has taken it, that is a matter for Parliament. Because Parliament now, in a reasoned way, will have to fashion a mechanism that strikes a balance.
Yeah.
Right now, the balance has been tilted or overturned.
Right.
Because you have now an employer who becomes helpless and hapless against the workforce, who can strike at their will and expect payment.
And then seek relief.
So the industrial relationship has now become absolutely unequal. If you read any industrial law book, they will tell you, and talk to any trade union, they always got to manage how long they will keep a strike on for. Because they always know that you're not going to get pay. So it was always a battle. How much pressure the employer will take before he buckles.
Exactly.
That is why you strike when cane is about to cut. Because you have the employer against the wall. You have a perishable product in the field. If you're a stevedore, you strike when the boat
comes
is on the wharf.
Yeah.
You got the employer against the wall there. He got to come to you because you're in a position of strength. Now the worker is all year round in a position of strength. So that's why I'm saying it's much larger than this
The
case.
implication there is serious.
It has destroyed industrial relations. And that is why, Nazim, no judge, these are not issues that have not gone before the courts. We have given the judge numerous cases in the Caribbean. That's why I don't believe in going to India on these matters or going to Canada. We have identical constitutional positions here, identical common law, identical social and industrial history and environment. And repeatedly these cases have come and they have been they have been rejected. These arguments have come and they have been rejected. Countries such as, for example, Trinidad, I know, has established an industrial tribunal and they have put statutory laws in place to regulate strike actions. A judge didn't do it. You know why they put statute in place? Because the statute creates a balance. And you know what the statute says in Trinidad? The statute expressly says that your right to strike is subject to the no work, no pay principle. Expressly, they maintain that position.
Yeah.
If you don't maintain that position, my brother, you have destroyed the fiber of the relationship.
Well, I want to ask you a question about what he determined, because I wasn't in court for everything when the trial, when he was hearing all the cases, but you were. He determined that because the government, the Ministry of Education, did not negotiate in good faith, therefore, right, he's going to rule because the negotiation process broke down or it was done in bad faith or the government was belligerent, because he kept using these very strong language.
We will deal with the language separately.
But he made that ruling that because the government, in his estimation, and based on the evidence before him, did not negotiate in good faith. Therefore, the government caused the strike and therefore should pay.
Now, wittingly or unwittingly, what the Honorable Judge has done is that he has laid the platform for every single strike action now to end up in the court. Why? Because every employer will say that he is reasonable and that the worker is unreasonable. Every union will say that the union is reasonable and the employer is unreasonable. To determine the reasonableness now or the lack of reasonableness, how do you determine that? So the court will now become an industrial center. That is not the function of the court.
That's a good point.
Right?
Yeah, that's a very important point.
This was not a well thought out judgment, and I say that with the greatest of respect. And you know, Nazim, in the course of the arguments, I don't know if you were there when I was presenting. I try my best to allude to all these eventualities, to give various version of events that will flow, that are untenable if this ruling comes in the way that I advise him not, well, I argued against him going, which eventually went. All these eventualities.
Right.
Because, as I said, no union will accept that they are unreasonable, and no employer would accept that they are unreasonable. So, what will be the position? The workers will not get the pay anyhow. The workers will not get the pay anyhow. They will have to go to the court.
Yeah.
You see, because that is his ruling. If the strike is reasonable, the worker must be paid. Who determines the reasonableness?
I want to ask you a question.
How do you leave that out there? Every strike and industrial action
All right.
will require adjudication by the courts.
Well, what does that do to investment in Guyana?
Well, that is the larger question. And I keep saying that, and that's why I began by saying that this case, while it concerns the narrow issue of GTU, this thing has domino effects and implications of enormous proportions. The magnitude of the repercussions that are flowing here, that will flow here, permeate the entire investment climate, the entire private sector, the entire industrial climate of the country. I, growing up, knowing from a sugar village that when workers strike, they can't get pay, and that's why they keep the strike at a minimum. You got to get strike relief for them. The union is under pressure. The union got to budget money as strike reliefs. The union themselves, this union, General Secretary Coretta McDonald, is on television saying that let them take the salary. We will find other means. In other words, she's a seasoned trade unionist. She recognized that it is a right of the government to take the salaries and that they have corporate sponsors. That was a recognition of the state of the law until the judges changed it.
Yeah. Wow. I want to ask you about the language, because I'm sitting there in court and he has a very rich number of adjectives to describe the government, to describe the Ministry of Education, to the Ministry of Labor. What do you make of this aggressive, intemperate language that the judge used today?
So, the legal profession has a long history going back to centuries. Has always, over and above all the professions, been regarded as honorable and as noble. And lawyers have been expected and are expected to carry themselves with a degree and an aura of moral rectitude, an aura of approbation, an aura of nobility. It's called the honorable profession. Many may disagree, but that's the history and that's the current position. Judges who are on the bench and to whom we are required to bow, lawyers and litigants alike, are of a special pedigree. They are elevated to a even higher status. With that status comes a responsibility. I had to explain to someone just before I came to the studio that judges enjoy complete immunity on the bench. Nothing that they say or even write can be the subject of legal proceedings. Now, that's an unusually high power, an unusually great power that is in your hands. The greater the power, the greater the responsibility. As a result, judges are enjoined to conduct themselves with a degree of rectitude. They are to use language that is judicious, and that's how the term judicious came about.
Mm-hmm.
They have to be measured, and you heard the language used by this judge. I was surprised.
Mm-hmm.
I was taken aback by the language, the excessive repetition of the language. Judges rule against litigants every day. That's part of your function. And this is done every day, everywhere, every part of the world. But it's done the way it ought to be done. Witnesses appear before tribunals and before judges every day. Many times, or most times, it is part of the people's function. It's part of their job that they are doing, and they are required to testify about it. They are not a party to the proceedings. They may not even have an interest in the proceedings. But because of the course of their employment, they are required to conduct certain duties. And if those duties become the subject of court proceedings, then they are required to testify on a particular issue. Some very regrettable language was used to describe public officers. One of them who testified. Now, if you don't believe a witness's testimony, then you just say that you don't believe the testimony. But to go on almost, you know, I have myself have to restrain because I might commit the same error in trying to explain what I believe the judge did, which he should not have done. I can't commit the same error here. But it was injudicious, it was intemperate, and it was embarrassing. You know, letters were reviewed, and the contents of the letter remarked upon with such caustic language that for me, it was a strange experience.
Yeah.
It was a strange experience.
I want to ask you about the dues, the union dues, because I understood that to be a favor that the government was doing to the union. But again, the judge, Justice Kisun, in this particular case, made some rulings in relation to the collection of dues, that they were, you know, the government was punishing the union by inflicting undue harm on teachers by not collecting these dues and so on and so forth. What do you make of that?
First of all, right across planet Earth, there are unions doing their business, enjoying protection by law and under constitutions across the Commonwealth. The obligation of the employer first of all, an employer never has an obligation that the law recognizes to assist the union. None. For obvious reason. These are the people who are going to campaign and canvass against you. In law, you are taken to be at arm's length. You don't have to help them. You don't have to give the man a bullet to shoot you. I mean, I'm being literal here, right? So that people could understand. But both have been able to maintain their respective positions. Every union would have its wherewithal on how to sustain itself, how to survive, how to maintain its militancy, its membership, etc. It may be through union dues, it may be through loans, it may be through fundraising, whatever it is. That is the union's business. So there is no obligation at common law. I don't know of any statute in the Caribbean that has created such an obligation. If government wants, they can do it as a matter of policy. If employers want, they can do it as a matter of policy. This government, our government of Guyana, even under the previous administration, apparently was doing it as a matter of policy. That is executive policy. It is not grounded in contract. It is not grounded in any collective bargaining arrangement. It is not grounded in the Constitution. It is not grounded in law. So it is gratuitous. Gratuitous means I am doing it at my own will, at my own volition, at my own motion, as a result of my own choice. That's what gratuitous means. I'm not getting anything in reward for it.
Yeah.
Any gratuitous action can be terminated anytime.
Right.
Or else people will stop doing gratis. Gratis means exactly that.
Yeah.
And ex gratia payment means you're not entitled to it. So apparently now the government is compelled forever to continue to do this favor. Now just hear that. How can you compel another entity to continue doing a favor for another entity? One entity to do a favor for another.
Perpetuity.
In perpetuity. At what level does that make rational sense? So that's the first principle I want to put out. The judge then went, so I said, this is executive policy. The judiciary can't inquire into executive policy. If the executive policy is wrong, we are answerable to the electorate. We are answerable to the judiciary for law, legal obligations, legal duties. This is not a legal duty. This is executive policy. That's what we have been elected to do. You follow me?
Yes, absolutely. Yeah.
Parliament is not answerable to the courts only if Parliament violates the law. That is why every time they took the Parliament to court, I've been able to succeed in arguing that they can't inquire into the business of the Parliament. You can't inquire into who the government decides to appoint a minister unless the government violates a law. Or the government decides to promulgate this policy. If we decide not to plant black eye tomorrow, that's a government decision, that's a government policy that is insulated from judicial review, right? Because no law is involved. So that's the second issue. So the court ought not even inquire there. Thirdly, the GTU argues that the government is extending this facility to other unions, and they have not led a shred of evidence to support that. In fact, by using a case called Nanda Gopal and the Public Service Union, that case dealt with a challenge by the union of a decision of Permanent Secretary Nanda Gopal to stop collecting union dues on behalf of the Public Service Union from public servants. In other words, The evidence that the judge had before him was a case in which the government did exactly this, terminated the collection of union dues. And there is no evidence that it is doing that for any other union. So contrary to what the other side is saying, that we are doing it for other union, the only evidence that is before the court is a case where the government has not done it. And by doing it for GTU, the government was discriminating in favor of GTU, not against GTU.
Wow. Interesting.
So,
Yeah.
so he said that. But the judge didn't leave it there. He went to a third ground.
Oh, okay.
He said, he said to take the union dues, or rather to discontinue the collection of the union dues for the union. You are violating the constitutional right of the union to conduct its business. That is why I began by telling you that there are unions all over the world who collect their union dues themselves.
Yeah.
The Public Service Union, since the decision of Gopal, as far as I'm aware, collecting their union dues by themselves. And that didn't affect their fundamental rights.
It's a courtesy.
This court.
It's a courtesy that an employer does
Yeah,
for
but
the union.
But somebody collecting it for you, when they decide to stop collecting it, they are affecting you, your constitutional right to associate and to be part of a union.
No.
So a union then must always depend upon some agency extrinsic to the union collecting union dues for and on behalf of the union. Isn't that the implication of the ruling?
Yes, that's the implication. Absolutely. Let's, we have a few minutes left to conclude our discussion. Obviously, there are people who are going to spin this as the government is, against teachers, which, would be an unfortunate, sort of propaganda that is perpetuated out there or put out there. I want to ask you about how do you go about, repairing this image if it needs repairing? Is there something that your government is going to do to foster a better relationship with teachers so they don't be this acrimonious perception in the public or among teachers that the government is against them?
We have never had an acrimonious relationship with our teachers. We have been in government now since '92, and then with a brief break between 2015 and 2020, and we have not had a bad relationship at all with teachers. In fact, we have had multi-year arrangements and agreements going forward in teachers. We have had, in fact, we have a better relationship with our teachers than we have had perhaps with other public servants, right? So we have not had, and we don't intend to have, a difficult relationship with our teachers or any public sector worker or private sector worker. We are a working class government. We have always said so. But there are rules of engagement. There are rules of engagement. The president himself announced that we are prepared to sit at the table and negotiate everything. But the teachers first demand that they want retroactive salary. How can we pay one segment of the public sector retroactive salary in the face of provisions in the Constitution that protects against discrimination? Are we not discriminating there? The teachers sat back and received all the public sector wages increase. They accepted them. They acted upon them. They continue to negotiate with the government. And that's the other part of the ruling. 4 years of engagement between the teachers' union and the ministry, and the judge found that there was no collective bargaining. Now, I don't know whether the union leadership and the leadership of the Ministry of Education were discussing their personal business, the individuals who were there.
Right.
What were they talking about? How did you get a whole menu of measures?
Is it factual that of the 4-1 demands that the union put forward, that 25 were already fulfilled over and beyond what they've asked for.
And
Is that
and
fact?
That's a fact, and that came from the engagement, and that was admitted by the person in the witness box on behalf of the union. That
Yes, I
there was a
there when that happened.
spreadsheet
Yes.
that Saddam Hussein tendered in evidence that listed all the measures, and the gentleman from the union accepted that.
I was there when he did, yeah.
You were there when he
Yes,
did.
yeah.
And the judge said that the spreadsheet was incredible.
Yeah, he said that, yeah.
The witness on the other side accepted it. They admitted to it in their affidavit as well.
So thank you very much. This was an enlightening discussion. I mean, you've laid out a case and a response that is detailed, that is factual. Thank you very much, Mr. Anil Nandlall, and sorry to bring you in on a Friday afternoon.
No, I just hope, Nazim, that I have not disrespected the judiciary.
No.
It was not my intention to disrespect the judge. The judge has given an unusual decision. I am the Attorney General of this country. I owe a public duty to the people of this country to explain this decision. It has far-reaching ramifications for workers and employers alike, way outside of the spheres of government, in the private sector and everywhere else. And it's my duty to come here and try to explain the judge's decision. I have tried to obey all the tenets of speaking critically of a judge and his decisions. I hope that I have not
Cross the line now.
I have not crossed the line, obviously, but there's a word that I want to use. I did not attribute to the judge any ulterior or malicious motive. The judge has ruled, and we have indicated that we will exercise our right of appeal, and we intend to do so.
Thank you very much, sir.
You're welcome.